Hello everyone, welcome to Mind Lawholic. In this video, we will discuss right against exploitation. This is a continuation video of constitutional law, case laws related MCQ video series. So starting with the first question. In which of the following cases the Supreme Court observed that labor taken from prisoners without paying proper remuneration comes within the forced labor? Options are A. Deena versus Union of India, B. Menaka Gandhi versus Union of India, C. Sanjit Roy versus State of Rajasthan, D. All of the above. The correct answer is A. Deena versus Union of India. Question number 2. In which of the following cases the Supreme Court has elaborately issued the guidelines on child labour under Article 23 of the Constitution of India? A. MC Mehta versus State of Tamil Nadu, B. Bandhwa Mukti Morcha versus Union of India, B. Madan Gopal versus State of Orissa, D. Both options A and B. The answer is MC Mehta versus State of Tamil Nadu and B. Bandhwa Mukti Morcha versus Union of India. Question number 3. Supreme Court of India issued directions to the central government to conclude the national survey on drug abuse within a period of 6 months and a national plan for curbing increase of use and abuse of substance in the children within 4 months in A. Bandhwa Mukti Morcha versus Union of India, B. NC Mehta versus Union of India, C. Bachpan Bachao Andolan versus Union of India 2017 and D. Sheila Barse versus Union of India. The answer is C. Bachpan Bachao Andolan versus Union of India. Question number 4. Match list 1 with list 2 and give the correct answer by using the codes given below. The list 1, Rajesh Gupta versus State of UP. It's about reservation of women. B. Attorney General of India versus Lachma Devi, execution of death sentence by public hanging. C. Avinash Mehrotra versus Union of India. It is about right to safe education. And D. Vishal Jeet versus Union of India, traffic in human beings including Devdasis. Question number 5. Payment of wages lower than the minimum wages is violative of Article 23 is declared by Supreme Court in A. PUDR versus Union of India, B. Sanjit Roy versus State of Rajasthan, C. Deena versus Union of India and D. Bandhwa Mukti Morcha versus Union of India. The answer is A. PUDR versus Union of India. Now let's see questions related to right to freedom of religion. Question number 1. In the case of John Vellamontan versus Union of India, AIR 2003, the Supreme Court held that Section 118 of the Indian Succession Act is violative of the Article A. 25 and 26 of the Constitution, B. Article 21 and 32 of the Constitution, C. Article 32 and Article 226 of the Constitution, and D. Article 136 and Article 141 of the Constitution. The correct answer here is A. Article 25 and 26 of the Constitution. Question number 2. In which of the following cases the Supreme Court held that while guaranteeing the fundamental right to the freedom of religion, explanation 2 to Article 25 Clause 2 Subclause B made it clear that reference to Hindus shall be construed as including a reference to persons professing the Sikh, Jain or Buddhist religion, and the reference to Hindu religious institution shall be construed accordingly. It was held in options A. CWT versus R. Sridharan, B. Shastri Yagna Purushdas Ji versus Muldas Brudardas Vaishya, C. Bai Vajia versus Thakkar Bai Chalbhai, D. Bani Bai versus Raghubir Prasad. The correct answer is B. Shastri Yagna versus Muldas. Question number 3. Which is not a leading case on the freedom of religion? A. S.P. Mittal versus Union of India, B. John Vellamontan versus Union of India, C. A.S. Narayan versus State of MP, D. Bobby Art International versus OPS Hoon. The answer is D. Bobby Art International versus OPS Hoon. Question number 4. Secularism is one of the 5 constituents of the Constitution of India and has been held to be the only permissible religion in the pluralistic Indian society. In the case of A. I.C. Golaknath versus State of Punjab, B. Keshwananda Bharati versus State of Kerala, C. S.R. Bommai versus Union of India, D. S.L. Kapoor versus Union of India. The answer is S.R. Bommai versus Union of India. Question number 5. Secularism as the basic structure of the constitution has been held to be so on the basis of more than 50 years experience of the working of the constitution. The complete apathy for all kinds of religious teachings in institutions of the state have not helped in removing mutual misunderstanding and intolerance inter se between sections of the people of different religious faiths and beliefs. This was stated by the Supreme Court in A. Aruna Roy versus Union of India. B. Arundhati Roy versus Union of India. C. P.A. Inamdar versus State of Maharashtra. D. Unnikrishnan versus State of AP. The answer is A. Aruna Roy versus Union of India. Question number 6. The Supreme Court observed that noise pollution cannot be tolerated even if such noise was a direct result of and was connected with religious activities in case of A. AP Pollution Control Board versus Professor M.V. Naidu. B. Church of God Gospel in India versus KKR Majestic Colony Welfare Association. C. K.M. Chinnappa versus Union of India. D. Narmada Bachao Andolan versus Union of India. The answer is B. Church of God in India versus KKR Majestic Colony Welfare Association. Question number 7. In which of the following cases did the Supreme Court hold that the petitioners have no fundamental right within the meaning of Article 25 or 26 to perform Tandava dance in the public streets and public places? A. Commissioner HRE versus Shri Lakshmindra Tirtha Swamiyar of Shri Shirur Math. B. Tilkayat Shri Govindalji Maharaj versus State of Rajasthan. C. N. Adityan versus Travancore Devosam Board 2002. D. Commissioner of Police versus Acharya Jagdishwarananda Avadhuta. The answer is D. Commissioner of Police versus Acharya Jagadishwarananda Avadhuta 2003. Question number 8. In which case the Supreme Court of India held that there is no jurisdiction for permitting only Brahmins to carry out necessary rites and rituals as priests? A. Aruna Roy versus Union of India. B. Ismail Faruqi versus Union of India. C. Bhuri Nath versus State of Jammu and Kashmir. D. N. Adityan versus Travancore Devosam Board. The answer is D. N. Adityan versus Travancore Devosam Board 2002. Now we shall see questions related to cultural and educational rights. Question number 1. Right of minority educational institutions is upheld in the following case of A. DAV College versus State of UP. B. Balsara versus State of Bihar. C. TMA Pai Foundation versus State of Karnataka. D. Daniel Latifi versus State of Kerala. The answer is C. TMA Pai Foundation versus State of Karnataka. Question number 2. Educational institutions can have their own fee structure, but there must be no profiteering and capitation fee cannot be charged. In which of the following case the Supreme Court observed this? A. Islamic Academy of Education versus State of Karnataka. B. Ram Sharan Maurya versus State of UP. C. Christian Medical College Vellore Association versus Union of India. D. INRE Kerala Education Bill. The answer is A. Islamic Academy of Education versus State of Karnataka. Question number 3. In which of the following case Supreme Court held that the idea of giving special rights to the minorities is to give them a sense of security and feeling of confidence? It was held in A. Ram Sharan Maurya versus State of UP. B. Islamic Academy of Education versus State of Karnataka. C. Christian Medical College Vellore Association versus Union of India. D. Frank Anthony Public School Employees Association versus Union of India. The correct answer is D. Frank Anthony Public School Employees Association versus Union of India. Now we shall solve questions related to right to constitutional remedies. Article 32. Question number 1. Which of the following case was the first case where the strict adherence to rules of locus standi was diluted? A. Ratlam Municipality case. B. Sunil Batra case. C. Sarla Mudgal case. And D. None of the above. The answer is A. Ratlam Municipality case. Question number 2. In which one of the following case did the Supreme Court rule that the principle of sovereign immunity will not apply to a proceeding for award of compensation for violation of fundamental rights? A. G.K. Krishnan versus State of Tamil Nadu. B. Neela Bhatti Behra versus State of Orissa. C. Kasturilal versus State of UP. D. State of Rajasthan versus Vidyavati? The answer is B. Nilabati Behra versus State of Orissa. Question number 3. In which of the following case compensation was first time awarded for violation of fundamental rights? A. Sunil Batra versus Delhi administration. B. Rudal Shah versus State of Bihar. C. Dharam Singh versus State of Jammu and Kashmir. D. None of the above. The answer is B. Rudal Shah versus State of Bihar. Question number 4. The case in which the Supreme Court has issued a writ of continuing mandamus was A. State of Punjab versus Sukhpal Singh. B. Subhash versus State of Bihar. C. Vinit Narayan versus Union of India. D. Gracie versus Kerala. The answer is C. Vinit Narayan versus Union of India. Question number 5. The fundamental rights to move the Supreme Court has been described as the cornerstone of the democratic edifice raised by the Constitution. As such, the Supreme Court must always regard it as its solemn duty to protect the said fundamental rights zealously and vigilantly. This has been stated by the Supreme Court in Daryao versus State of UP. B. Bandhwa Mukti Morcha versus Union of India. C. Sheila Barse versus Union of India. D. MC Mehta versus Union of India. The answer is A. Daryao versus State of UP. Question number 6. Read assertion and reason and answer using the codes given below. Assertion: the writ of habeas corpus can be granted to enable the detainee to argue his case in person. No, this is wrong. Reason: because R versus Secretary of State for Home Department ex parte Vinay decided so. No, even the reason given here is wrong. So the correct answer should be both A and R are wrong. Question number 7. A suit lies against the government for death or injury caused to a person by police atrocities as held in A. D.K. Basu versus State of West Bengal. B. Saheli versus Commissioner of Police. C. Bhim Singh versus State of Jammu and Kashmir. D. A.K. Gopalan versus State of Madras. The answer is B. Saheli versus Commissioner of Police. Question number 8. In which of the following judgment the scope of the writ of habeas corpus was widened? A. D.K. Basu versus State of West Bengal. B. Sheila Barse versus Union of India. C. Sunil Batra versus Delhi administration. D. MC Mehta versus Union of India. The answer is C. Sunil Batra versus Delhi administration 1978. Question number 9. In which of the following cases the Supreme Court refused to give any relief to the petitioners under Article 32? A. Swaraj Abhiyan versus Union of India. B. Bachpan Bachao Andolan versus Union of India. C. Supreme Court Women Lawyers Association versus Union of India. D. Suresh Chand Gautam versus State of Uttar Pradesh. The answer is D. Suresh Chand Gautam versus State of Uttar Pradesh. Question number 10. In which of the following cases the Supreme Court has held that the government employees can also file public interest litigation, since the right to judicial remedies is a constitutional right available to all citizens of India? A. Vijay Shankar Pandey versus Union of India. B. T.S.R. Subramaniam versus Union of India. C. Manohar Lal Sharma versus Union of India. D. Abhay Singh versus Union of India. The answer is A. Vijay Shankar Pandey versus Union of India. Question number 11. Match the following. List 1. ADM Jabalpur versus Shivkant Shukla. The answer is habeas corpus case. B. MSM Sharma versus SK Sinha. The answer is Searchlight case. RC Cooper versus Union of India. That is bank nationalization case. And RK Garg versus Union of India is bearer bonds case. Question number 12. No PIL under Article 32 will be entertained concerning the interstate river waters was said by Supreme Court in A. State of Bihar versus Kameshwar Singh. B. Thakur Amar Singh Ji versus State of Rajasthan. C. Atmalinga Reddy versus Union of India. And D. None of the above. The answer is C. Atmalinga Reddy versus Union of India. Question number 13. Rudal Shah versus State of Bihar 1983 is known for option D. Right to compensation. Question number 14. In which case the Supreme Court observed that intercaste marriages and adoptions were two important social institutions through which secularism would find its fruitful and solid base for an egalitarian social order under the Constitution of India. This was said in A. Aruna Roy versus Union of India, B. Valsamma Paul versus Cochin University, C. Mohanlal versus District Magistrate, and D. None of the above. The answer is B. Valsamma Paul versus Cochin University. Question number 15. In which of the following cases Supreme Court of India has held that public interest prevails over private interest? A. S.K. Ray versus State of Orissa, B. Union of India versus International Trading Company, C. Punjab Communication Limited versus Union of India, and D. None of the above. The answer is C. Punjab Communication Limited versus Union of India, where the Supreme Court held that public interest prevails over the private interest. So let us wind up the video here. Thank you for watching.